try to tell you that how you need to solve those particular question along with the explanation. So now I'll request each one of you to please participate and show your enthusiasm to evaluate and boost your performance regarding the Bihar Judiciary preliminary examination. Next thing, that in the end of the session, we'll definitely discuss about the Judiciary 𝘧𝘓 course. So stay tuned with us, and we'll definitely tell you a brief about that. So now, as the organizer today, we have with us Mahima Khurana. She is an associate at 𝘧𝘓. Also, she is a course crash course anchor, along with Jolly Tiwari. She is an associate at 𝘧𝘓. So I welcome you both for this session, and now I'll request each one of you to kindly guide us through this particular quiz. How many number of questions we are about to get, and I'm very excited. So let's begin.
Okay, so thank you Anu for introduction. So guys, lastly we conducted 2 live mocks on constitutional law and history and current affairs. So this is our 3rd mock of 𝘧𝘓. So there might be some discrepancy if you have only seen the poster, but if not points of discussion. तो poster में ये mention था कि contracts and law of torts है, but ये नहीं था कि live mock है. But points of discussion में हमने mention किया था कि there will be live mock. So this session is all about 50 questions, out of which 25 questions will be of torts and 25 questions of law of contracts. So I will be going on with tort, and then Mahima will be taking forward with law of contracts. So guys, 50 questions है, time 1 hour से ज़्यादा भी लग सकता है. So let's test you as well as हमें भी टेस्ट करना है. ये चैलेंज है हमारे लिए कि हम कितने कंसिस्टेंट रह सकते हैं. अगर हम यहाँ 1 घंटे भी नहीं बैठ पा रहे हैं तो वहाँ एग्जाम में हम कितना अपने आप को, मतलब आप समझ सकते हो ना, 1 घंटे तो आपको बैठने की आदत डालनी होगी. और एग्जाम इज लाइक नॉट टू फार एंड नॉट टू क्लोज, ऑलरेडी पोस्टपोन हो चुका है. दैट डजंट मीन्स कि आप प्रैक्टिस ही करना छोड़ दो. तो फॉर दैट केस कितनी बार होता है कि आपको लाइव फ्री मॉक्स करने को मिलते हैं. वी आर गिविंग यू दिस अपॉर्चुनिटी, just utilize it, grab it and try to practice more and more. We will be coming with more of these. So without wasting time, start करते हैं.
Yes, yeah, before starting our session, same 2 rules we'll follow. You have to mention the question number. I'm telling and emphasizing those who are newly added with us. So first of all, you need to mention the question number along with the answer or your option respectively. Secondly, you do not have to mark 2 answers for the same question. So this is it from my side. So let's start.
Okay guys, so you did like understand कि क्वेश्चन के साथ ही आंसर मतलब देने हैं, अदरवाइज ट्रैक करना हमारे लिए भी डिफिकल्ट हो जाएगा और आप भी मार्क्स लूज कर सकते हो. एंड वन मोर थिंग, देयर इज नो नेगेटिव मार्किंग इन एग्जाम्स as well as this live mock. So try to give more and more answer, participate more and more. Okay, so first question, the word tort is derived from option 1 Latin word, option 2 French word, option 3 English word, option 4 Roman word. Your time starts now.
We are providing 30 seconds, right?
20 seconds now because I have already read the question and the options. So 20 seconds.
All right. Please guys mention your question number along with your answer.
So tort is derived from like Latin है कि French है, English word है या Roman word है. Just it's a very basic question. इतना तो like tort law के बारे में हमें पता होना चाहिए. Tort law basically हमें law school में first या second year में ही पढ़ा दिया जाता है. Like first year में like tort law is like taught to us. तो बहुत easy है, like हम forget कर सकते हैं after 5 years. So it is necessary कि आप इसको revise करते रहें. चलो time's up.
Okay. What is the correct option?
Option 1 Latin word. Option 1 Latin word.
All right. Let me just write down the correct answers.
tort has been derived from the Latin word tortum, which means to twist. Thus, it means the conduct which is not lawful, but rather it is twisted, crooked, or unlawful. Like not totally lawful कि उसको criminal या civil में डाल दे, but it is also crooked, twisted, and unlawful. तो tort law like थोड़ा confusing भी है, but it is very interesting. Okay, Anu, should I move forward?
Yes.
Okay. The pigeonhole theory has been given by option 1 Salmond, option 2 Winfield, option 3 Pollock, option 4 both 1 and 2. Pigeonhole theory, try to remember guys, किसने दी थी? Time is already running. Pigeonhole theory का meaning क्या था? इसको tort law में कैसे apply किया गया? And इसका like pigeonhole होता क्या है? इसका tort law में क्या वो है? तो अगर आपने पढ़ा होगा so it will get easy for you. ऐसे क्वेश्चन BGS में पूछे गए हैं.
Yes, one more thing there. The people who have entered into this webinar without their names, I'm just naming one of them, 50046D8. So please write your name, then start answering, because your name is not there, so I'm not able to, keep writing your number again and again. So it will also help us to announce if you are giving the right answer. तो हम name भी आपका announce कर पाएंगे if you stood as a winner.
Okay, time's up.
All right.
Answer is option 1, Salmond. To the law of torts consists of set of neat of pigeonholes, each containing a specific labeled tort. When the defendant's wrong does not fit in any of these pigeonholes, he is said to have committed no tort. This theory is also known as pigeonhole theory. So tort law इसमें चेक किया जाता है कि कहीं ना कहीं तो जो भी crime commit हुआ है किसी ना किसी tort में तो आ जाएगा. सैलमन ने ये थ्योरी दी थी, और अगर वो उसमें नहीं फिट होता है किसी भी स्पेसिफिकली लेबल्ड टॉर्ट में, लाइक बैटरी, असॉल्ट, ट्रेसपास, तो उसको लाइक वो टॉर्ट के उसमें नहीं आएगा.
ओके.
नेक्स्ट क्वेश्चन. Question 3. Tort means option 1 a wrong, option 2 a civil wrong, option 3 a legal wrong, option 4 all of the above. Very basic question, and try to remember the definition of tort given by various people. So अगर आपने definition अच्छे से पढ़ी होगी, आपको meaning पता होगी tort का, तो आप easily ये question answer कर लोगे. तो आप देख रहे हो BGS में इतने ज्यादा difficult questions नहीं आए torts, and tort is however not a very difficult subject. इसको थोड़ा सा पढ़ना जरूरी है.
Yes, attendees, it's a very good, quiz we are going on. So just please write your question number also.
And try to answer more and more, please. Try to participate more and more. Try to test yourself. It's a challenge for you. Let's see who sits with us till 1 hour. How many participants are left after this 1 hour? Let's see. Okay. Answer is option 2. A legal civil wrong. However, every civil wrong is not a tort. Like in case of breach of contract, the wrong is not a tort, like not a tort wrong, because उसमें unliquidated damages की बात नहीं होती है. चलिए explanation भी एक बार मैं read कर लेती हूँ. तो answer is Anu, option 2.
Yes. Okay.
Okay. A civil wrong is a private wrong, and the injured party's remedy is to sue the party who caused the wrong for general damages. The plaintiff sues or brings a civil suit against the defendant. So tortious liabilities actually means civil wrong, which does not arise of contractual obligations. Okay, let's move forward to this question. Okay. Question 4. In what ways person can be discharged from the tortious liability? Option 1, death of the either party. Option 2, waiver of tort. Option 3, statute of limitation. Option 4, all of the above. तो इस केस में बहुत सारे वो केसेस हैं जिन केस में पर्सन कैन बी डिस्चार्ज फ्रॉम द टॉर्चरस लाइबिलिटी. पार्टिसिपेंट्स टाइम इज ऑलरेडी रनिंग, सो ट्राई टू सी कि ये जो तीनों चीजें हैं क्या वो फिट हो रही हैं उन केसेस में, या वन ऑफ देम इज रॉन्ग, या टू ऑफ देम इज रॉन्ग, या ऑल ऑफ देम आर करेक्ट, माइट बी करेक्ट. So try to remember कौन सी ऐसी liabilities है जिसमें tort कि वो नहीं लगेगा आप पे, discharge हो जाओगे आप उस ड्यूटी से, tort liability से. So participant time is already running. Are we having answers, Anu?
Yes, a lot.
Okay. So many of you know this question. Great. Okay, let's see the answer. Time is up, huh?
Okay, please stop answering.
Answer is all the above. Option 4. Question 4, option 4.
All right.
So, in case of death of the parties, the common law maxim action personalis maritim cum persona, which means personal right of action dies with the person. So, in this case, अगर death हो रही है किसी one of the parties की, तो automatically the liability will get discharged. Then law of limitation. Law of limitation means the law prescribes a time limit within which an action must be brought for the wrong. And if this prescribed period is over, the right of action is barred and remedy cease to operate. अब कोर्ट भी उन्हीं की हेल्प करता है जो खुद की हेल्प करते हैं. तो विद इन टाइम यू शुड बी डिलिजेंट अबाउट योर राइट्स. तो अगर आप एक पर्टिकुलर मेंशन टाइम के अंदर अगर आप अपना वो लेके आ रहे हो तो कोर्ट विल कंसिडर, अदरवाइज नो.
ओके.
और यहाँ पे वेवर ऑफ टॉर्ट भी दिया था. वेवर ऑफ टॉर्ट मतलब वन ऑफ द पार्टी खुद कहती है कि नो वी डोंट वांट टू पुट एनी एलिगेशन अगेंस्ट द अदर पार्टी. तो एक वेवर हो जाता है राइट का. Okay. Let's move forward to the next question. Okay.
Yes.
Meaning of ubi jus ibi remedium. Option 1. When there is a right, there is a remedy. Option 2. When there is a remedy, there is a right. Option 3. There is no wrong without a remedy. Option 4. Both 1 and 3. Okay. So here you have to tell the meaning of ubi jus ibi remedium. So it's आपको मीनिंग पता होगी तो ही आप ये आंसर कर पाओगे. This is very commonly used in the in any law books और आपको पढ़ाया जाता है आपकी कॉलेज में भी, तो आपको ये पता होना चाहिए. Okay, not much time is left, guys. Tick tick 3, tick tick 2, tick tick 1. Time's up.
Yeah, please stop answering.
Answer is option 1. When there is a right, there is a remedy. So the maxim ibi jus ibi remedium means that where there is a right, there is a remedy. Or there is no wrong without a remedy. However, the maxim does not lay that there is a legal remedy for every wrong. Thus, the wrongs not recognized by law are not actionable. So you can see here there are provided two options. यहाँ पे आप confuse भी हो सकते थे कि option 1 से है या option 2 से है, because दोनों में ज़्यादा difference नहीं. But the correct option is option 1. When there is a right, there is a remedy. Okay. Anu, so answer was option 1. Should we move forward?
Yes.
Question 6. It is a civil wrong for which the remedy is a common law action for unliquidated damages and which is not exclusively the breach of contract or the breach of trust or other merely equitable obligation. This definition has been given by option 1, Winfield, option 2, Salmond, option 3, Fraser, option 4, Mullah. तो ये डेफिनेशन किसने दी थी? विनफील्ड ने दी थी, सैलमन ने दी थी, फ्रेजर ने दी थी या मुल्ला ने दी थी. ये डेफिनेशन टॉट की है, वेरी नोन पर्सन ने दी थी. और अभी हम कुछ क्वेश्चंस में मैं आपको हिंट देते हैं, उनकी बात कर भी चुके हैं ऑलरेडी. So not much time is left, guys.
And still people and those who are not following the rules, I'm not going to mark their answers.
Guys, question then answer so that we can at least track. आपकी मेहनत भी नहीं वेस्ट जाएगी और हमारी मेहनत भी वेस्ट नहीं जाएगी. We will easily track. अनु को ज्यादा परेशान मत करो guys. Okay, time's up. Answer is option 2, Salmond.
Okay.
Question 6, option 2.
All right.
Okay, okay. Should I move forward?
1 second, just give me. All right, you can move forward. Yes,
Which
Jolly.
statement is correct for an act of tort? Question 7. It is a civil wrong. All civil wrongs are not tort. It gives a right and rem. All of the above. So see the most appropriate answer here. इसमें से कौन सा most appropriate answer होगा? क्या पता all of the above भी हो. So try to read the question. Try to read the option more and more, and try to recall the definition of tort. Okay, guys, try to give more and more answers. इतना difficult नहीं है law of torts and law of contracts. I want more and more answers, and I want कि इस बार out of 50 you are scoring more than 40. Whoever comes first, second or third. Okay, time's up.
All right.
Answer is option 4. All of the above. Question 7, option 4, all of the above.
Okay.
Okay. So we come to question 8. Which case had introduced the policy of privity of contract? Which case had introduced the policy of privity of contract? Option 1, Donock versus Stevenson. Option 2, Ryland versus Fletcher. Option 3, Winterbottom versus Wright. Option 4, Grant versus Australian Knitting Mills Limited. So यहाँ पे बहुत फेमस केस लॉ की बात हो रही है, और आपने मेनली केस पढ़ा होगा. ऐसा हो ही नहीं सकता अगर आपने लॉ ऑफ टॉर्ट्स पढ़ा और ये केस नहीं पढ़ा हो. इट्स अ वेरी फेमस केस. Okay, are we having answers?
Yes.
Okay. Guys, try to assess yourself, assess your preparation. Okay, time's up. Answer is option 3, Winterbottom versus Wright. So in this case of Winterbottom versus Wright, for the first time the doctrine was recognized. In the first, like privity of contract was recognized first in this Winterbottom versus Wright, in which a postal service wagon driver was injured due to faulty wheel, attempted to sue the manufacturer Wright for his injuries. The court, however, decided that there is no privity of contract between manufacturer and the consumer.
Okay, so which option is correct?
Option 3, Winterbottom versus Wright. Option 3. Question 8, option 3.
All right, give me just 2 seconds.
Okay.
All right. Done.
Question 9. A person who knowingly and without sufficient justification induce another to break a contract with third person, whereby the third person suffers damage, is a tort. For the first time, it was established in which of the following cases? First, Ford versus Lindsay. Second, Limley versus Guy. Third, Deny versus Peak. Fourth, MC Manus versus Bonus. It's a little typical question. Let's see who are the participants जो इसका आंसर देते हैं. थोड़ा इजी नहीं है ये क्वेश्चन, ये कैटेगरी डिफिकल्ट में आएगा क्योंकि ज्यादा लोगों को पता नहीं होगा ये, आई गेस, बट ये बिहार में पूछा गया. These are the question of past years जो बिहार में ऑलरेडी पूछे गए हैं. So I have put up from there only.
Yes, we are going to receive 4 to 6 questions.
Guys, negative marking नहीं है, at least guess ही कर लो.
Okay.
Don't be particular about giving like answer. अगर आपको नहीं पता तो आप guess कर लो, वहां भी fill करके ही आना अपनी OMR sheet में, क्योंकि वहां भी negative marking नहीं है बिहार में.
Jolly?
Yes?
We still have time?
No. We are out of time. Sorry.
Okay.
Okay. Answer is option 2. Lumley versus Guy. Option 2. Question 9, option 2.
Okay.
Okay, okay. Should I move forward?
1 second. Option 2 is correct, right?
Yes, yes, yes. Option.
Okay, yeah, please.
Question 10. The essentials needed for taking the defense of act of God. Option 1. Working of natural forces. Option 2. Occurrence needs to be extraordinary. Option 3. Occurrence can't be anticipated and reasonably guarded against. Option 4. All of the above. So guys, try to recall ये डिफेंस एक्ट ऑफ गॉड का किन किन सिचुएशंस में मिलता है, क्या सब में मिलता है, क्या 1 और 2 में मिलता है, या बस किसी एक में ही मिलता है. ट्राई टू रिकॉल. ये बहुत ही इस पे तो मूवी भी बन चुकी है एक्ट ऑफ गॉड में, हॉलीवुड में भी और यहाँ बॉलीवुड में भी. तो इट्स अ वेरी नाइस एंड बेसिक थिंग कि एक्ट ऑफ गॉड किस किस केसेस में यूज कर सकते हैं फॉर द डिफेंस इन केस ऑफ टॉर्ट्स. आंसर करो, ज्यादा नेगेटिव मार्किंग नहीं है. आई एम सेइंग दिस कॉन्टिन्यूअसली सो दैट आप एक आपकी प्रैक्टिस हो जाए, वहां भी आप यही करके आओ. Okay, time's up.
Yeah, please stop answering.
Answer is option 4, all of the above. So in all the 3 cases, we can take, these are the essential of taking defense under act of God. So for taking defense of act of God, one needs to prove that the act has been occurred due to natural calamities and there is no human control upon it. It is extraordinary and can't be predicted and controlled by any prudent human being. Okay, so option 4 was the correct answer for this question 10. So should we move forward?
Yes.
Okay. Question 11. Which of the following does not fall within the meaning of term 𝘬𝘪𝘵𝘊 debt? First, an immoral debt. Second, an illegal debt. Third, a debt resulting from the Torts Act. Fourth, suretyship debt. Guys, it's a bit tricky question and I've kept it like intentionally कि देखते हैं कि कितने लोग इसको आंसर कर पाते हैं. 𝘬𝘪𝘵𝘊 debt. So are we receiving answers, Anu?
Yes. The frequency is good.
Okay, okay. Okay, time's up. Answer is option 4, suretyship debt.
Option 11, answer 4, right?
Answer is 4, question 11, option 4. Answer is option 4, suretyship debt.
Let me just write it down.
Okay, okay.
Okay, please move ahead.
Okay. Question 12. Whether for a wrong, both tortious and criminal liability may arise. Option 1, only tortious liability may arise. Second, only criminal liability may arise. Third, both the liabilities may arise. Fourth, none of the above. So guys, कोई wrong commit हुआ है तो क्या दोनों liabilities उस केस में हम मतलब हो सकती है कि tort भी लग जाओ, criminal law की भी हम कुछ sections लगा दें? कैसा ऐसा is possible है हमारे इंडियन लॉ में? Is it possible? तो आप देख रहे हो कि यहाँ पे कैसे क्रिमिनल को भी जोड़ा गया है टॉर्ट के साथ. इस टाइप के क्वेश्चंस भी फ्रेम हुए हैं बिहार में. तो इतना हल्के में भी नहीं लेना है बिहार को, खाली डायरेक्ट क्वेश्चंस ही आएंगे. आप देख सकते हो टॉर्ट्स में कितने ट्रिकी क्वेश्चंस पूछे हैं बिहार में. So let's see the answers.
Yes.
Answer is option 3. Both the liabilities may arise. Answer is option 3.
Okay.
Okay. So some wrongful acts may be both a crime and a tort. Example ले लेते हैं. Like an assault generally requires an offensive touching. If someone assaults you, the state may decide to prosecute that person under the criminal law. If the state proves its case beyond a reasonable doubt, the person is considered guilty of the crime and may be penalized criminally. In addition, you may decide to bring a civil tort lawsuit against the wrongdoer. Your lawsuit would be separate from the criminal proceeding. If you prove that a person assaulted you in your tort case and that you suffer damage as a result, and you may receive money damages for the wrongful conduct. तो क्रिमिनल डैमेजेस के लिए तो पनिशमेंट मिलेगी, लेकिन जो टॉर्ट के लिए आपको लाइक नॉमिनल डैमेजेस या मनी डैमेजेस मिल जाएंगे. तो आप देख रहे हो कि ऐसे सिचुएशंस में दोनों लाइबिलिटीज अराइज हो सकती हैं. Okay, let's move forward to the next question.
Yes.
Question 30. Again, the meaning of 𝘬𝘱𝘵 per allum 𝘱𝘵 per se. Option 1. The act of an agent is the act of agent itself. The act of principal is the act of principal himself. Third, he who acts through another does the act himself. Both none of these. अब इसमें से right meaning कौन सा है इसके लिए? 𝘬𝘱𝘵 per allum 𝘱𝘵 per se. तो guys, it's a basic question. ये तो पढ़ाई होता है हमने अपने लॉ स्कूल में. तो देखते हैं. आई फील कि इसके लिए ज्यादा से ज्यादा आंसर्स आएंगे. मुझे लगता है सबको पता ही होगा.
Yes, and mostly I believe correct भी है.
Okay, okay. So, okay. Okay, time. Tick tick 4, tick tick 3, tick tick 2, tick tick 1. Time's up. Answer is option 3.
Yes.
Okay, 𝘬𝘱𝘵 per allum 𝘱𝘵 per se is a Latin legal term that means he who acts through another does the act himself. It is a fundamental legal maxim of law of agency. It is maxim often stated in discussing the liability of employer for the act of employee in terms of vicarious liability. यहाँ पे एक और केस है, अगर एम्प्लॉय अगर कोई भी ऐसी कोई रॉन्ग कमिट कर रहा है, जब तक वो उसका टाइम पीरियड है कि वो ड्यूटी में है और इन द फॉर द पर्पस ऑफ ड्यूटी वो कुछ काम करने गया है, तो उसके लिए एम्प्लॉयर लायबल होगा क्योंकि वो उस टाइम पीरियड में गया और उसका पर्पस भी उसी से रिलेटेड था. अगर वो उस टाइम पीरियड में नहीं गया होता, किसी और टाइम में कुछ कर रहा होता, तो एम्प्लॉयर वोंट बी लायबल, बट यहाँ पे वाइकेरियस लायबिलिटी अराइज होगी. ओके, आंसर वाज ऑप्शन 3.
Okay.
Okay. Question 14. The doctrine of liability of the master for the act of a servant is based on the maxim. Option 1. 𝘬𝘱𝘵 per allum 𝘱𝘵 per se. Option 2. Voluntary non-fit injuria. Option 3. Act of third party. Option 4. Respondent superior. तो थोड़ा मिलता जुलता है ये हमारी प्रीवियस से, बट इतना भी नहीं. तो ट्राई टू रिकॉल किस मैक्सिम से इसका मीनिंग वो है. अभी आपने देखा मैक्सिम का मीनिंग पूछा गया, अब मीनिंग रख दिया गया और हम मैक्सिम पूछ रहे हैं. तो मैक्सिम्स बहुत पूछे गए बीजेस में, एंड टॉट लॉ इज अबाउट लिटिल अबाउट मैक्सिम्स एज वेल. सो ट्राई टू आंसर मोर एंड मोर. ये हमें पढ़ाया जाता है हमारे लॉ स्कूल में. अलग से एसेंशियल वो होती हैं इसकी कैटेगरीज, मास्टर सर्वेंट की, एम्प्लॉयर एम्प्लॉय की, तो इसके इसमें आपने पढ़ा होगा. Okay. Time's up.
Yes, please stop answering.
Stop answering, everyone. Answer is option 4. Respondent superior. Option 4. The doctrine of liability of the master for the act of a servant is based on the maxim respondent superior, which means let the principal be liable, and it puts the master in the same position as if he had done the act himself. तो अगर सर्वेंट कोई एक्ट कमिट कर रहा है इन टर्म्स ऑफ हिज ड्यूटी एंड इन द टाइम जिसमें वो अपनी ड्यूटी सर्व कर रहा है, तो उसके लिए मास्टर लायबल होगा. तो वी गेट दिस मैक्सिम रिस्पोंडेंट सुपीरियर. ओके,
Alright.
ओके. क्वेश्चन 15. इन लॉ ऑफ टॉर्ट्स nominal damages are awarded. Option 1 as compensation for nominal injury. Option 2 for the recognition of legal right. Option 3 for the recognition of human sufferings. Option 4 as a compensation for damages. So guys, nominal damages का मीनिंग क्या होता है टॉर्ट लॉ में? nominal damages कब अवॉर्ड किए जाते हैं? क्या ऐसे कोई बहुत ग्रेव क्राइम होता है तब दिए जाते हैं, या फिर लाइक ट्राई टू रिकॉल द मीनिंग ऑफ नॉमिनल डैमेजेस. ऐसा हो ही नहीं सकता आपने लॉ ऑफ टॉर्ट्स पढ़ा हो और आपको नॉमिनल डैमेजेस नहीं पता हो. तो ट्राई टू गिव मोर एंड मोर आंसर. हो सकता है हम भूल गए हो, बिकॉज टॉर्ट लॉ हमें बहुत पहले पढ़ाया जाता है, और अगर हमारे रिविजन में नहीं रहेगा तो इट्स लिटिल बिट डिफिकल्ट टू रिकॉल. बट आई कैन लाइक अंडरस्टैंड कि अगर अब पेपर है तो आपको रिविजन करना स्टार्ट कर देना चाहिए. स्टार्ट विद टॉर्ट, ज्यादा टाइम भी नहीं लगेगा. मैंने पूछे भी गए काफी क्वेश्चन पे हाल में.
Okay.
Okay, so we are getting answers.
Yes, yes.
Okay. The time's up, guys.
Okay, please stop answering.
Answer is option 2. Nominal damages, usually of a token sum, are awarded where a tort is actionable per se and where the plaintiff is unable to prove any injury, loss, or damage. It provides mere recognition that the wrong has occurred, but where the wrong was not a serious infringement of the plaintiff's right. Well, very little damage was done. No, not all damage was done. It's a mere recognition. Just a little amount of compensation is provided. कि कोर्ट ने recognize किया कि हाँ wrong has been done, but no damage has been done. तो nominal damages in cases में provide किए जाते हैं under the law of torts. Okay.
Yes.
Question 16. If the servant commits any fraud during the performance of his duties, then the master would be held liable or not? No. Option 1, no. Option 2, yes. Option 3, depend on the discretion of the master. 4, none of the above. ऐसा एक क्वेश्चन हम पहले भी पूछ चुके हैं, तो guys easy होगा आपके लिए आंसर करना. Try to give more and more answers, and today I can see more and more participation, more than previously live mocks which we held. So I guess tort and contracts पसंद है काफी आप लोगों को. So
Yes.
okay, time's up.
All right.
Answer is option 2, yes. अगर सर्वेंट कोई रॉन्ग कमिट कर रहा है जब वो ड्यूटी में है मास्टर की, तो यस मास्टर वुड बी हेल्ड लायबल. ये काफी डायरेक्ट क्वेश्चन था और इसके पहले मैं ऐसा क्वेश्चन पूछ भी चुकी थी, तो आई गेस काफी लोगों ने इसका सही आंसर दिया होगा.
Yeah, mostly.
Okay, so should we move forward?
Give me 1 second.
Okay.
All right. Yes, please.
Okay, question 17. Right of action is extinguished by the death of one or another parties. The statement is true. Option 2, false. Option 3, true except in certain cases. Option 4, false except in certain cases. तो गाइस जो पहले से आंसर कर रहे हैं उनको तो पता होगा इसका आंसर. सो लेट्स सी आपका स्टेट ऑफ माइंड कैसा है, आपका प्रेजेंस ऑफ माइंड कैसा है. वेरी वेरी इजी एंड बेसिक क्वेश्चन. Okay, time's up.
Yeah, please stop answering. What is the correct option?
Answer is option 3, true except in certain cases. So under common law, the general rule was the death of either party extinguish any cause of action in tort by one against the other. This was expressed by the maxim action personalis moritum cum persona. अभी मैंने previous question में बताया भी था कि with the death the action liability also dies. So there are certain exception to this rule where cause of action survives even after death. Example, section 306 of Indian Succession Act 1925. So answer is option 3, true except in certain cases. Exception है इस statement के लिए.
Option
3.
3 is correct. Okay.
Yes, option 3, true except in certain cases.
All
So,
right.
okay. Question 18. An unlawful interference with person's use or enjoyment of land or some right over or in connection with it is known as tort of trespass. Option 1, nuisance. Option 2, negligence. Option 3, conversion. Option 4. So ये try to read question more than once, guys. आप confuse हो सकते हो between nuisance and conversion, या trespass and nuisance. I don't think so negligence से confuse होंगे, but I usually get confused in nuisance and conversion. So please try to read more and more this question. So आपको easily answer मिल जाएगा कि an unlawful interference with person's use or enjoyment of land or some right over or in connection with it. अगर इस चीज से कोई interfere कर रहा है तो वो किस tort उसके अंदर आएगा?
Jolly, yeah, just try to, speed up.
Okay. So, time's up.
Right.
Answer is option 2, nuisance. This will come under nuisance.
Okay.
Not conversion. Okay. Question 19. In which case fundamental test for determining duty to take care was laid down? Option 1, Bonnell versus Young. Option 2, Donogh versus Stevenson. Option 3, Haynes versus Harvard. Option 4, Heaven versus Fender. Very easy question, और ये केस तो हम मतलब लाइक बच्चों वाला क्वेश्चन है ये. ये केस मतलब सबको ही पता होता है, सबने ही पढ़ा है. केस काफी फेमस केस है ये. इसका एक दूसरा नाम भी है. Try to answer more and more, guys. टॉट लॉ खत्म ही होने वाला है. जस्ट 6 क्वेश्चंस मोर, उसके बाद हम कॉन्ट्रैक्ट्स पे आएंगे. सो ट्राई टू टेस्ट योरसेल्फ फॉर 6 more question in case of torts. Okay, time's up.
Yeah, please stop answering.
Answer is option 2, Donogh versus Stevenson. Option 2.
Okay, just wait.
So Donogh versus Stevenson, also known as the snail in the bottle case, is a significant case in Western law. The ruling in this case established a civil law tort of negligence and obliged businesses to observe a duty of care towards their customers.
Okay. Okay.
Question 20. Tort of defamation can be in respect of a living person only. Option 2, deceased person. Option 3, both 1 and 2. Option 4, either 1 or 2. Tort of defamation किसके against ही हो सकती है? Living person के against की, या फिर the person who is already dead, or both? Try to answer, guys, more and more. कोई negative marking नहीं है. And tort law is very interesting and very short. Okay, are we getting the answers? I know.
Yes.
Time's up.
Okay, please stop answering.
Answer is option 3, both 1 and 2. In case of deceased or living person, tort of defamation लगाया जा सकता है. Okay.
Option 3 is correct, right?
Yes, option 3.
Okay. Yeah, please move ahead.
Question 21. Prosecution under tort of malicious prosecution means: option 1, proceeding at a police station charging a person with a crime. Second, proceeding in a court of law charging a person with a crime. Third, proceeding undertaken by public prosecutor. Fourth, proceeding undertaken by public officer and public prosecutor. Try to read options like more carefully in this question. Okay, guys, after this only 4 more questions to go for law of torts. As you can see, यहाँ पे electricity नहीं आ रही है. I hope I'm not giving any ghostly vibes to anyone. Okay, let's see the answer. Time's up. Answer is option 2. proceeding in a court of law charging a person with a crime. Answer is option 2. Question 21, option 2.
Okay.
Okay.
Let me just.
Option 2 is the right answer.
All right, move ahead. Yeah.
Okay. Question 22. Tort is a special branch of law which originated in option 1 America, option 2 France, option 3 India, option 4 England. तो किस कंट्री में टॉर्ट लॉ ओरिजिनेट हुआ था? ओरिजिनेशन इंडिया की थी, इंग्लैंड की थी, फ्रांस की थी, अमेरिका की थी. टॉर्ट लॉ आया कहां से था? वेरी बेसिक क्वेश्चन. ये जब हम डेफिनेशन पढ़ रहे होते, डेफिनेशन से पहले लिखा ही होता है कि यहाँ से ओरिजिनेशन हुआ था. अब ऐसी चीजें भी पूछी गई हैं बिहार में. Okay, so time's up.
Yes, please stop answering.
Answer is option 4, England. Option 4, England.
Okay. Let me just.
Okay.
Option 4, right?
Yes, England.
All right. Please move ahead.
Question 23. To constitute a tort, option 1, there must be some act or omission on part of the defendant. Option 2, the act must result in violation of legal right vested in the plaintiff. Option 3, there must be a legal duty on the part of defendant. Option 4, both 1 and 2. अब टॉर्ट के केस में कॉन्स्टिट्यूट करने के लिए कौन कौन से एसेंशियल इंग्रेडिएंट होने चाहिए इनमें से? ट्राई टू सी द ऑप्शन, ट्राई टू रीड द ऑप्शन मोर एंड मोर. Okay. So are we having the answers, Anu?
Yes.
Okay. Okay. Thankfully.
What is the correct option?
Correct option is option 4. Both 1 and 2. Both 1 and 2.
Option 4 is correct, yeah.
Okay. Yes, option 4 is correct. Okay, let's move forward to the second last question of law of torts.
Yes.
Question 24. The general remedy in law of tort is action for damages, action for injunction, third, specific restitution of property, fourth, action for unliquidated damages. General remedy. Try to focus on general remedy here. Guys, try to give more and more answers. सारे answers दो, guess कर लो, कुछ भी कर लो, answers दो. वैसे भी ये सेकंड लास्ट क्वेश्चन है लॉ ऑफ टॉर्ट्स का, इसके बाद कॉन्ट्रैक्ट्स पे आने वाले हैं. Okay. Time's up.
We have received our answers. What is the correct option?
Okay. Correct option is answer 4. Action for unliquidated damages. Not unliquidated damages means not predetermined damages. Like in breach of contract, डैमेज हमें पहले से पता होते ही डिटरमाइंड होते हैं कि ये हुआ तो कॉन्सिक्वेंसेस ये होंगे. टॉर्ट लॉ में ऐसा नहीं होता है. तो लेट्स कम टू द लास्ट क्वेश्चन.
Yes.
Which one of the following is not libel? Option 1, a defamatory statement in print. Option 2, a cinematographic film. Option 3, pictures. Option 4, sound of gestures. Guys, try to remember the definition of libel and slander and libel के अंदर कौन कौन से, अब इसमें try to see कि क्या आएगा. थोड़ा tricky question है, but this has been asked in case in Bihar. So try to give more and more answer. Guess ही कर लो, क्या पता guess सही निकल जाए. Okay, so are we having the answers?
Yes.
Okay, time's up. Correct answer is option 4, sound of gestures. Option 4, sound of gestures.
Right.
Okay. So guys, these were the questions from my side. Now let's come to law of contrast, जो महिमा आगे लेके जाएंगी. So महिमा,
Yeah,
I would like to.
I also learned a thing or two जब मैंने ये questions देखे by Jolly. The set of questions were very good, I guess. और ये सारे questions we have picked them from the past year papers. Quickly, I'll start with the law of contracts, but उसके पहले law of contracts almost हर exam का major subject है. Guys, I can see you people exhausting. I can see you people leaving also. Stay with us. ट्राई टू आंसर द क्वेश्चंस. और क्योंकि बिहार एक ऐसा प्रीलिम्स का फॉर्मेट ऐसा, मेंस तो हर स्टेट का बहुत एग्जॉस्टिंग एग्जाम, बट प्रीलिम्स का बिहार पर्टिकुलरली ऐसा फॉर्मेट है कि दो एग्जाम्स होंगे. हाउ यू विल बी एबल टू सिट. अगर आप 1 घंटा हमें नहीं झेल पा रहे हो तो प्लीज ट्राई टू स्टे विद अस और थोड़ा सा और हिम्मत दिखाओ. कॉन्ट्रैक्ट्स, लॉ ऑफ कॉन्ट्रैक्ट्स इज कमिंग अप क्विकली. तो आई कैन शेयर माई स्क्रीन ना अनु?
Yes.
And I want full participation this time. Easy questions हैं as compared to बाकी other states के. थोड़े से questions easy हैं. So yeah, first question is which one of the following is correct? Which one of the following is correct? All agreements are contracts once they have been made between the parties for a consideration. All agreements are contracts once they have been made between the parties with their free consent. All agreements are contracts once they have been made between the competent parties. All agreements are contracts if they are made by the free consent of parties competent to contract for lawful consideration and lawful object and not expressly declared by law to be void. Try to find out the exact language. The most appropriate option would be correct here. बाकी वैसे correct और भी हो सकते हैं, but the most appropriate option is the correct answer here. So the time is just few more seconds left. Yes, the time is over.
Yes, please stop answering.
Yeah, so the correct answer to this question is option number 4. Anu, the correct answer is option number 4. सेक्शन 10 में ये एग्जैक्ट लैंग्वेज लिखी हुई है कि व्हाट अग्रीमेंट्स आर कॉन्ट्रैक्ट्स, और ये सारी चीजें वहां पे मेंशन्ड हैं जो ऑप्शन नंबर 4 में मेंशन है. इसलिए हमें कभी कभी क्वेश्चन को चारों ऑप्शन पढ़ने चाहिए. हम एक्साइटमेंट में पहला ऑप्शन पढ़ के दूसरा ऑप्शन पढ़ के मार्क कर देते हैं, बट डोंट डू दिस. आप सारे ऑप्शंस पढ़ो, देन फिगर आउट द राइट आंसर. सेक्शन 10 इज द रेलेवेंट सेक्शन हियर.
Right.
Are we getting the answers, Anu?
Yes, a lot.
Hello. बढ़िया. The next question is, an agreement enforceable at the instance of one party but not of the other is called a valid contract, an illegal contract, a void contract, a voidable contract. This is the, I guess this is the easiest of this slot. ये सबसे easy question है. Enforceable at the instance of one party but not enforceable at the instance of other party. एलिमिनेट करके भी आप यू कैन फिगर आउट द आंसर, और एलिमिनेट करने की वैसे तो इतनी खास जरूरत है नहीं. यू कैन जस्ट फिगर आउट द करेक्ट आंसर. द टाइम इज ओवर.
Right. Please stop answering.
द करेक्ट आंसर इज अगेन ऑप्शन नंबर 4, अवॉइडेबल कॉन्ट्रैक्ट. A void contract is void ab initio from the very beginning. An illegal contract is prohibited by law. A valid contract is valid, and a voidable contract is enforceable at the instance of one party but not of the other party. So this was the answer. Option number 4 is the correct answer.
Right.
Chalo. Next question is, an agreement to remain unmarried is, option 1 is valid, option 2 is void, option 3 is voidable, option 4 is unenforceable. ये काफी interesting question है. An agreement to remain unmarried is, if anyone wants you to be unmarried, such agreement is valid, void, voidable or unenforceable. There's a section, corresponding section here. Just 3 seconds left. As Rolly said, tick tick 1, tick tick 2, yeah, over.
Yeah.
So the correct answer is option number 2, void. Section 26 is the relevant section here, which makes all agreement in restraint of marriage void other than the agreement made with a minor. Minor is an exception here. Minor के साथ अगर आप ये agreement करते हो कि आप शादी नहीं करोगे अपने majority से पहले, तो वो valid है, unless otherwise all such agreements are void as declared by section 26. Option 2 is the correct answer.
Right.
When the consent to a contract is caused by coercion, the contract under section 19 is option 1 is valid, option 2 is voidable, option 3 is void, option 4 is illegal. Coercion. There's section also written there, section 19. And you can just remember what was the definition of coercion, and find out that okay, the time is over. We have given you 3 seconds extra. So the correct answer to this question is option 2, voidable. Such agreements are voidable and not void. Coercion से और जो fraud से और जो undue influence से agreements होते हैं वो सब voidable होते हैं, not void. So section 15 defines coercion and section 19 makes such agreements as voidable.
Okay, so option 2 is correct.
Option 2 is the correct answer. Voidable.
All right.
Chalo. Question number 30. Stay with us, guys. Participate करना ज़्यादा से ज़्यादा. A proposal when accepted becomes promise under section 2B, agreement under section 2E, contract under section 2H, none of the above. Definition clause contract act का सबसे important clause है और उसमें you can get almost all the basics clear from the definition clause itself. और definition clause में exact यही line लिखी है. A proposal when accepted becomes what? Time is over. Stop.
Yeah.
Yeah. So the correct answer is option number 1. A proposal when accepted becomes a promise and it is written clearly under section 2B. It becomes promise.
Right.
Okay?
Okay.
Shall I move forward now?
Yes.
Question number 31. Agreement, the meaning of which is not certain of or capable of certainty is voidable, illegal, enforceable, void. There is a corresponding section to this question also. वो section याद करो and then try to answer this question. जिसकी meaning certain नहीं होती हैं उन agreements का result क्या होता है? Are they void? Are they voidable? Are they illegal or enforceable? Okay, the time is up. Yes. The correct answer to this question is option number 4. Option number 4 is the correct answer, Anu.
Option number 4. 1 second. What is the option 4?
Void.
Void. Okay.
Section 29 makes such agreement as void. Guys, answer करो. सबके सब answer करो. सारे answer करो. Just because of the fact negative marking नहीं है. I want maximum participation at least in this session क्योंकि contract act बहुत main subject है. Constitution में भी participation था, history में भी participation था. I want same with contract act. So the next question is a contract which ceases to be enforceable by law. It is known as unenforceable contract, void contract, voidable contract, or contingent contract. A contract which ceases to be enforceable by law. The time is running. Quickly answer the question. I can see participants leaving. Don't leave, guys. Stay with us. Contract chal raha hai. The time is over. Yes.
Okay.
The correct answer is option number 2, void contract.
All right. Let me just note it down.
Yeah. Section 2G says that an agreement not enforceable by law is said to be void. जो law जिनको enforceable नहीं मानता, such agreements are void under section 2G of the Indian Contract Act. You can see most of the questions from definition clause itself. you can get at least 2 or 3 questions from the definition clause. So don't miss reading the definition clause and understanding the concepts in detail contract act की जब बात आती है. And this is not for Bihar, this is for every state जहाँ पे contract act पूछा जाता है, और maximum हर state का syllabus है contract act. Okay, so the next question is, which one of the following elements is not necessary for a contract? Competent parties, reasonable terms and conditions, free consent, lawful consideration. ये exact same question, exact तो नहीं, but हाँ मिलता जुलता question was asked before also. एक question था और section भी, I've told you the relevant section also. Section नहीं, don't open the section, don't open the bare acts. ये तो मैं बोलना भूल ही गई. Just answer the question by using your memory. You'll not get the bare acts there. This is not an open book exam. The time is up.
Right. Please stop answering.
The correct answer is option number 2, reasonable terms and conditions. Option number 2 is the correct answer.
Oh, okay.
Yeah. So section 10 prescribes these 3 conditions, and other than lawful consideration, without lawful object, such agreements are also not a contract. But competent parties, free consent, lawful consideration, and lawful objects are the main elements. Reasonable terms and conditions, there is nowhere written that this option number 2 should be there. So ये था answer. Option number 2. Chalo, let's move on to the next question now. 34. Question number 34 is based on a case law. The legal principle which was laid down in the case of Harvey versus 𝘱𝘰 was firstly followed by the Supreme Court of India in which one of the following cases? Badri Prasad versus State of Madhya Pradesh, Vyomkesh Banerjee versus Nani Gopal Banik, D.I. Macpherson versus M.N. Apanna, Carlyle versus Carbolic Smoke Ball Company. इस क्वेश्चन को ना ऐसे भी आंसर कर सकते हो कि कौन कौन से केसेस सुप्रीम कोर्ट के थे, बट अगर ये नहीं पता है तो देन द हार्वे वर्सेस 𝘱𝘰 इज द वेरी लीडिंग केस इन फॉर द इंडियन कॉन्ट्रैक्ट एक्ट. शुरुआत में ही हम इसे पढ़ लेते हैं, और उस पे बेस्ड एक सुप्रीम कोर्ट की फाइंडिंग भी थी. ओके, द टाइम इज ओवर. या
ओके, प्लीज stop. Yeah.
Are we getting the answers?
Yes, we are getting a lot of answers.
चलो, that's good. सबको पता है मुझे लगता है ये वाला क्वेश्चन. So the correct answer is option number 3. Macpherson versus Apanna was the case which was option number 3 is the relevant answer. Anu here.
Okay.
Yeah. So Macpherson versus Apanna था जो जिसपे हार्वे वर्सेस 𝘱𝘰, the famous bumper ball pen case, जहाँ पे lowest price बोला था and that was considered not to constitute an offer. तो वही उसी पे this Macpherson versus Apanna was the case by Supreme Court जो जिसपे same findings दी गई थी.
Okay, so correct answer of question 34 is option 3, right?
3. Macpherson versus Apanna.
Yeah, everyone has answered it incorrectly.
Why?
Okay.
Macpherson versus Apanna is the case. चलो कोई बात नहीं. Try to remember this कि Macpherson, मैं भी होती तो मैंने भी गलत आंसर देना था because I also thought कि बद्री प्रसाद है, but ठीक है. Macpherson versus Apanna is the relevant case.
Right.
चलो. The next question is, what would be the effect of mistake as to law enforced in India on a contract? What would be the effect of mistake as to law enforced in India on a contract? Is it void, voidable, not void, not voidable? वो वाले sections याद करो जहाँ पे mistake, जो mistake से deal करते हैं. Effect of mistake as to law, you'll get the answer. Mistake as to law. Time is up.
Okay.
What is the correct answer is option number 4, not voidable. अगर valid option होता, option number 4 is the correct answer. Anu here.
Okay.
Yeah. अगर valid option होता और not voidable भी option होता, आपको not voidable option mark करना होता, just because of the fact कि section 21 की language not voidable है and valid नहीं. Although the meaning of not voidable and valid is same, but not voidable है is the correct answer. Not valid अगर होता तो, the valid option was not there, so the correct answer is not voidable. Mistake as to law enforceable in India. India में not voidable है. अगर foreign law के context में mistake पे question आता, तो then such agreements are void.
Option 4 is correct, right?
Yes, option number 4 is the correct answer, not voidable.
अभी ranks में difference आ रहा है.
चलो सही है. Indian Contract Act is such an act जो ranks में difference लाता है reality में. चलो. The next question is, in standard form of contract, the individual has no choice but to accept. The individual has many choices to accept or refuse. The agreement is without consideration. None of the above. Option A clear है answer. What is the standard form of contract and what is the correct answer here? Eliminate करके भी you can figure out the answer very easily. The time is up.
Yes, please stop answering. Yeah, please.
अन्नू को परेशान मत करो. जब वो बोले stop answering, then please stop answering. So the correct answer is option number 1. The individual has no choice but to accept.
Option 1.
Yeah, 1 is the correct answer. A standard form of contract where the other party has little or no ability to negotiate. Standard form से आप ऐसे मैंने तो ऐसे याद करा है where the parties has no ability to negotiate, no negotiable powers, more favorable terms, and is thus placed in a take it or leave it position. Take it or leave it standard form of contracts होते हैं, तो the individual has no choice but to accept. Option number 1 is the correct answer here.
Okay.
The next question is, if the bailee without the consent of the bailer mixes the goods of the bailer with his own goods in such a manner that it is impossible to separate the goods and deliver them back, the bailer is entitled to be compensated by the bailee for the loss of goods, compensated by the bailee for half of the loss of goods, compensated by the bailee for 1/4 of the loss of goods, civil imprisonment for maximum 6 months. The time is already running, guys. Whenever I start reading the option, you should start answering the question because options तो आपके सामने screen पे आपको दिख ही रहे हैं.
Yes, we have received our answers.
Yeah, the time is also up.
Okay, stop.
So the correct answer is option number 1. Option number 1 is the correct answer here. Compensated by the bailee for the loss of goods. Section 157 says that कि अगर कहीं पे भी ऐसी situation आ जाती है जहाँ पे goods को separate नहीं करा जा सकता, it is impossible, then the bailee should be the person जो compensate करेगा for the loss of the goods.
Okay.
ठीक है, the option 1 is the correct answer. हम सोचते हैं कि bailment agency नहीं, bailment और indemnity guarantee से इतने questions नहीं आएंगे, but questions आते हैं. A continuing guarantee may be revoked for further transaction. A continuing guarantee after an year, after 6 months, after 3 months, at any time. This is the question from guarantee, the concept of guarantee. Try to remember the concept of guarantee and try to remember continuing guarantee. You will get the answer. Section याद करने की कोशिश करो. After a year, after 6 months, after 3 months, at any time. Okay, the time is up now.
Yes, please stop.
The correct answer is at any time. Option number 4 is the correct answer.
Okay.
Section 130 says that a continuing guarantee which is for many continuous transactions, such guarantee can be revoked at any time. No such time limit is mentioned under the Indian Contract Act. So the correct answer is option number 4.
Okay. Yes.
Okay, are we getting the answers, Anu?
Yes.
चलो ठीक है. Don't leave us, guys. यहाँ पे थोड़े से ही बचे हैं, 10-11 questions बचे हैं. You can answer this. You can sit with us. A guru, spiritual advisor, induced the chela, his devotee, to give him whole of his property to secure benefit of his soul in the heaven. This gift shall be void, voidable, valid, or immoral. The time is started. इलिस्ट्रेशन बेस्ड क्वेश्चंस की बहुत चांसेस है इंडियन कॉन्ट्रैक्ट एक्ट में. एक ऐसा क्वेश्चन बिहार में अभी पहला आया है, तो ये क्वेश्चन बहुत आते हैं. ऐसे कोशिश करो इस क्वेश्चन को आंसर करने की कि पहले देखो कि क्या हुआ है यहाँ, और वो वाले जो अग्रीमेंट्स होते हैं वो उनका रिजल्ट क्या होता है. ओके, द टाइम इज अप.
Yes, please stop. What is
correct answer is option number 2, voidable.
Okay.
Because The consent was induced by undue influence. The guru उसने अपनी authority का misuse करके उसको पूरी property उससे ले ली. That is the reason the answer to this question is voidable. The consent was induced by undue influence. Undue influence से जब भी कोई ऐसे agreements होते हैं तो then such agreements are voidable and not void.
Option 2 is correct.
Yes, voidable.
Okay.
Chalo. Question number 40 is Section 128 of the Indian Contract Act 1872 is related with sureties, liability, continuing guarantee, revocation of continuing guarantee, consideration for guarantee. ये section based question है. This is I think this is one of the easiest questions here. तो ये तो बहुत आसानी से आंसर हो जाएगा if you remember the index of the Contract Act. ज़्यादा sections भी नहीं है इस act में, तो you can easily remember the sections and their corresponding marginal notes. तो आप इससे आसानी से आंसर कर सकते हो. The time is up now.
Okay.
Yes. Answer 1 is the correct answer. Sureties liability. Sureties liability is coextensive with that of the principal debtor. तो जो principal debtor की liability होगी वही surety की होगी. The correct answer is option number 1. Anu, are you getting enough time to mark? Should I go slow?
No, I'm comfortable.
चलो ठीक है. So the next question is, which one is the famous case related with the general offer? Come on, this question should be answered by each one of us. हमको सबको बताए आंसर. लालमन शुक्ला वर्सेस गौरी दत्त, मोरी बीबी वर्सेस धर्मदास घोष, कार्लिल वर्सेस कार्बोलिक स्मोक बॉल कंपनी, मैकफर्सिस वर्सेस अपन्ना. एक ऑप्शन तो ऑलरेडी डिलीट हो चुका है क्योंकि हमें पता है कि वो क्वेश्चन था पहले. आई कैन सी पीपल लीविंग. स्टे विद अस गाइस. आंसर करो क्वेश्चन. केस लॉ पे तो क्वेश्चंस आते ही हैं. कॉन्ट्रैक्ट एक्ट में, टॉर्ट्स में बहुत फेमस केस है. ओके, द टाइम इज अप नाउ.
ऑलराइट.
जनरल ऑफर का सबसे लैंडमार्क केस है ऑप्शन नंबर 3, कार्बोलिक स्मोक बॉल कंपनी केस. कार्डिल वर्सेस कार्बोलिक स्मोक बॉल कंपनी. ऑप्शन नंबर 3 इज द करेक्ट आंसर. जहाँ पे उसको उसके फैक्ट्स कुछ ऐसे थे ना, जहाँ पे उसको इन्फ्लुएंजा की मेडिसिन उसने ली थी और उस पे लिखा था कि अगर आपका ठीक नहीं होती है ऐसी कोई डिजीज तो वी वुड बी गिविंग यू सम अमाउंट ऑफ प्राइस. तो उसने उसको स्यू कर दिया था कंपनी को. एंड इन दिस केस, पर्टिकुलर केस, उसको दिया गया था उसका कॉम्पनसेशन, बिकॉज दिस इज द केस रिलेटेड टू जनरल ऑफर, क्योंकि कंडीशन उसने सारी परफॉर्म करी थी एज इट वाज रिटन इन द मेडिसिन बॉटल, सिरप थी शायद. सो दिस इज द करेक्ट आंसर. ऑप्शन नंबर 3 इज द करेक्ट answer. Okay?
Yes.
Chalo. Question number 42 is, consent will be said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation and mistake. The term free consent has been defined in which section of the Contract Act? Section 14, section 15, section 16, section 17. It is again this is the easiest question. You can easily answer this question अगर आपको index पता हो. And the confusing section is not there in the option. अगर section 13 होता तब तो फिर थोड़ा बहुत confusion की chances होती थी, but section 13 नहीं है, तो you can easily answer this question now. Tick tick 1, tick tick 2, tick tick 3. Okay, the time is up.
Right.
The correct answer is option number 1. Section 14 defines free consent. Section 13 defines the only word consent. Option number 1 is the correct answer. फ्री कंसेंट, ये सारी चीजें लिखी हुई हैं सेक्शन 14 में. सेक्शन 13 सिर्फ कंसेंट डिफाइन करता है, इट डजंट डिफाइन फ्री कंसेंट. तो अगर सेक्शन 13 होता तब तो कंफ्यूजन की चांसेस भी थी. बाकी तो सारे सेक्शंस हमें पता ही है. 15 कोर्जन है, 16 अनड्यू इन्फ्लुएंस है एंड 17 इज फ्रॉड.
Yes.
चलो आगे चलें.
Yes.
43. An agency under the Contract Act is terminated by principal revoking his authority, the death of either principal or agent, principal being adjudicated as insolvent, all of the above. Come on guys, ये common sense use करके हम आंसर कर सकते हैं ऐसे questions को. और नहीं तो if you remember the section also, then it is very good, क्योंकि agency थोड़ा last का topic है. It is relatively difficult for me at least कि उनके sections याद करें. Only 5 seconds are left. Up the time. Yes. The correct answer is option number 4. All of the above. All of the above is the correct answer. Section 201 is the relevant section here. जो ये बोलता है कि एजेंसी इन तीनों चीजों से टर्मिनेट हो सकती है. जब भी कोई एजेंट अपने प्रिंसिपल के लिए ऑन द बिहाफ ऑफ हिज प्रिंसिपल परफॉर्म द एक्ट, तो वो रिवोक टर्मिनेट इन तीनों चीजों से हो सकती है. ऑप्शन नंबर 4, ऑल ऑफ द अबव.
Okay, done.
In Indian law, a wagering contract is treated as voidable, treated as void, treated as against public policy, treated as valid. In Indian law, tricky तब होता है जब पूछते हैं not in Indian law, in England law. तो Indian law तो हमें पता है कि कौन सा सेक्शन है और कौन सा आंसर है. It is very easy to answer this question. 3 seconds left. Over. The time is up. The correct answer is option number 2. A wagering contract is void under section 30. Option number 2 is the correct answer. England में such contracts are not only void but also illegal. It is punishable also. Wagering contract in England में void नहीं illegal भी होता है, but India में such contracts are, such agreements are void.
Yeah, 5 more questions, guys.
Guys, please buck up. 5 questions बचे हैं. This can make or break. Rank बढ़ा सकते हैं. And the questions are relatively easier. बिहार में अगर हम बिहार की बात करें तो क्योंकि direct questions हैं. Every promise and every set of promise forming the consideration for each other is an offer, an agreement, an acceptance, a contract. Exact यही चीज, यही definition लिखी हुई है कहीं पे contract act में. अगर आपने वो clause अच्छे से पढ़ा है, वो section अच्छे से पढ़ा है, then you can easily answer this question. 5 seconds more, guys. Up. The time is over.
Stop.
Yeah. So the correct answer is option number 2, an agreement. Section 2E defines agreement. Option number 2 is the correct answer.
Yes.
Every promise. Yeah.
Some people marked it wrong because they are continuing giving the correct answers. तो मुझे लगता है शायद question अच्छे से नहीं पढ़ा हो.
Read the question carefully, guys. Question number लिखो 45 और उसके बाद option number 2 लिखते तो correct होता. An agreement is the right answer here. Every promise and set of promises forming the consideration for each other is agreement. Section 2E defines such term. Exact definition लिखी हुई है वहाँ पे. You can open section 2 and see the exact definition there. Chalo, the next question is, in order to convert a proposal into a promise, the acceptance of proposal must be absolute and unqualified. The acceptance of proposal must be valid. The acceptance of proposal must be conditional. The acceptance of proposal must be absolute, vested, or conditional. There's an exact section regarding this. आपको आराम से आंसर पता होना चाहिए इसका. Only 2 seconds are left. The time is up now.
Stop. Now stop. Still people are answering. I'm watching everyone.
Don't answer, guys. Will not be counted. अगर आप time के बाद answer करोगे. And सबसे बड़ी बात है, I can see people leaving. Don't leave us. Stay with us. Please try करो answer करना. This is important for you also. क्योंकि contract act तो है ही. So the correct answer is option number 1. The acceptance of proposal must be absolute and unqualified. Absolute and unqualified. Option number 1. Section 7 of the Indian Contract Act mandates that an acceptance of an offer must be absolute and unqualified, expressed in some reasonable manner and also unconditional. The term absolute means it should be unconditional. So the option number 3 already gets eliminated because condition to ho hi nahi sakti acceptance. So the first option is the correct here. Okay, shall I move forward now?
Yes.
3 questions left, guys. Don't leave us. Stay with us. Try to answer more and more questions. We'll be seeing कि कौन-कौन ने सबसे अच्छा answers दिए. A contract made by a minor is void ab initio. It is laid down in, okay, I can see already the answers are coming. Kanhaiya Lal versus Ghedari Lal, Mohammad Saeed versus Vishambhar Dayal, Mori Bibi versus Dharmodash Bose, Lalman Shukla versus Gauri Dutt. Very easy and very famous case. कंट्रैक्ट एक्ट की बुक खुलते ही ये केस आता है सबसे पहले. Very easy case. The time is up. Okay, the correct answer, Anu, here is option number 3. Mori Bibi versus Dharmodas Ghosh. The other party here was Brahmodat. तो अगर ऐसा पूछा जाता है कि who was the plaintiff, तो आपको मोरी बीबी और धर्मदास घोष नहीं लिखना है, Brahmodat was the other party here. Option number 3, because sometimes such question also comes. So Mori Bibi versus Dharmodas Ghosh is the landmark case when it comes to minor. Contract made by minor is void ab initio. ठीक है?
1 second. Yes, please move ahead.
Keep on answering, guys. Keep on participating. The last third question is, good displayed in the showcase of a shop with a price tag is an offer, an invitation to contract, a counter offer, none of the above. Good displayed in the showcase of a shop with a price tag. Remember you guys going to a showcase and picking up one of the goods with a price tag. What is it? Is it an offer? Is it an invitation to offer? Is it a counter offer? The time is up. The correct answer is option number 2. It is not an offer but an invitation to offer. Just an invitation to offer. Option number 2 is the correct answer here.
Yeah.
Okay. आप जाते हो, it is not said to be an offer. जैसे आप कोई भी चीज उठाते हो किसी भी शोकेस से जहाँ पे सेल्फ सर्विस स्टोर्स होते हैं, वहाँ पे आप कोई भी चीज उठाते हो, it is not an offer but an invitation to offer. It will become an offer जब सामने जो काउंटर पे बैठा है कैशियर वो एक्सेप्ट करता है आपका invitation to offer, then it becomes an offer. Option number 2 is the correct answer.
Okay.
Yeah. The last second question, guys. 2 marks की बात है.
What was the correct? 48 option
2.
Second was correct, right?
Invitation to offer.
Yeah. Okay.
चले आगे.
Yes.
An agreement in connection with horse racing under section 30 is unlawful, voidable, void, valid. चलो थोड़ा सा तो इसमें दिमाग लगेगा कि सेक्शन 30 क्या है और सेक्शन 30 में हॉर्स रेसिंग आती है, तो क्या है उसका करेक्ट आंसर. Unlawful, voidable, void or valid. Try to remember what is section 30, what is the nature of such agreements, and then try to remember its exceptions. ये भी मैंने बता दिया, तो फिर आपको पता चल जाएगा आंसर. Tick tick 1, tick 2, over.
Yes, please stop.
Yeah, the correct answer is option number 4. Such agreements are valid. Option number 4 is the correct answer here.
काफी लोग कंफ्यूज हो गए इसमें.
हाँ, क्योंकि section 30 makes such agreements, wagering agreements as void, but horse racing उसका एक exception है जो इंडिया में allowed है in spite of being a wagering in nature.
काफी लोग कंफ्यूज हुए. Yeah.
So this was the trickier one. बिहार इतना आसान भी नहीं है गाइस, थोड़ा तो देगा ना, मतलब थोड़े तो ऐसे क्वेश्चन होंगे जो घुमाएंगे. So the last question for today's mock is, A agrees with B to trace out the secret money for him by the way of magic. This agreement is void, voidable, enforceable, legal and enforceable in Bengal. ये ऑप्शन थोड़ा सा कंफ्यूज कर सकता है, बट या दिस इज रिलेटिवली इजियर वन. हमें पता है इसका आंसर क्या है. ट्राई टू रिमेम्बर द सेक्शन, रेलेवेंट सेक्शन, और यू कैन जस्ट फिगर आउट द आंसर इलस्ट्रेशन पढ़ के. अगर जादू से कोई मैजिक हमको बोलता है कि हम फिगर आउट करके देंगे तुमको, तो सच एग्रीमेंट्स आर व्हाट. ओके, टाइम इज अप. द करेक्ट आंसर इज ऑप्शन नंबर 1, void. सच एग्रीमेंट्स आर. जादू जैसी कोई चीज नहीं होती है गाइस, पढ़ना पड़ता है और तभी हमारे मार्क्स आते हैं, इसलिए तो सच एग्रीमेंट्स आर void.
Please don't answer up. I'm not counting. Okay, so I'll get back till the time you take over the webinar.
Okay, cool. ठीक है, तो Anu is counting the marks, guys. I can just see 27 contestants here now. 40 contestants थे जब हमने webinar join किया था. More than 10 contestants couldn't bear us for 1 hour only. I hope कि बाकी सारे लोग
Okay, so it's itself is a teach like achievement for these 26 participants कि वो हमारे साथ for वो 1 hour हमारे साथ उन्होंने bear किया.
26 including three of us. There are 23 participants.
Yes.
So 3 participants.
So ये itself एक achievement है हमारे लिए. And guys, wait, we will be announcing winners as well in this webinar only at the end. So I hope you got an idea कि बिहार में इस टाइप के questions पूछे जाएंगे. सो उसके अकॉर्डिंग आपको प्रिपेयर करना है. एंड टॉट लॉ का आइडिया लग गया, आपको कॉन्ट्रैक्ट्स का लग गया. इसके पहले हमने कॉन्स्टिट्यूशनल लॉ, हिस्ट्री, करंट अफेयर्स पे भी लाइव मॉक किया था, तो उससे आपको उनके क्वेश्चंस का भी आइडिया लग गया होगा. तो एक तरीके से आपके प्रीलिम्स की प्रिपरेशन अच्छी खासी हो गई होगी अब तक बिहार की. एंड नॉट साइंस पे भी वेबिनार है हमारा, एक लाइव मॉक है ऑन मंडे, तो उसको भी प्लीज डू अटेंड. तो उसके बाद आपकी लाइक एक होल प्रिपरेशन हो जाएगी फॉर प्रीलिम्स. ओके
गाइस, बिहार के क्वेश्चंस थोड़े इजी हैं जस्ट बिकॉज ऑफ द फैक्ट क्योंकि उनका पूरा पेपर 1 इज बेस्ड ऑन जीएस, जीके and other things, current affairs also. Some questions are also asked from current affairs. तो बिहार का क्वेश्चन पेपर 2 जो लॉ वाला है उसमें थोड़े से डायरेक्ट क्वेश्चंस हैं, पास्ट ईयर पेपर से ऐसा एनालाइज करा गया है. बट द पॉइंट इज कि जो पास्ट ईयर पेपर्स में हुआ क्या पता वो अब हो या ना हो, है ना. तो यू कैन नॉट टेक चांसेस. आप सिर्फ आराम से नहीं पढ़ सकते हो. लॉ के सब्जेक्ट भी यू हैव टू स्टडी इन डेप्थ. तो बिहार के क्वेश्चंस थोड़े से इजी हैं, बट जो दूसरा स्टेट आ रखा है मध्य प्रदेश, उसके क्वेश्चन बिल्कुल भी इजी नहीं है. और सीपीसी और सीआरपीसी तो बिल्कुल बहुत ज्यादा प्रोसीजरल लॉ, तो स्पेशली दे फोकस ऑन द मेन फोकस इज ऑन सीआरपीसी एंड सीपीसी. तो डोंट ट्राई टू थिंक ये थोड़ा सा इजी क्वेश्चन थे तो ऐसा हो जाएगा. इजी थे क्योंकि हमने पास्ट ईयर से ही उठाए हैं. पास्ट ईयर में थोड़े से डायरेक्ट क्वेश्चन हैं, कुछ क्वेश्चंस हैं, बट कट ऑफ भी उसी हिसाब से जाएगा क्योंकि ऑल ऑफ अस आर एबल टू आंसर दीस क्वेश्चंस, नो. तो कट ऑफ भी उसी हिसाब से जाएगा. और पेपर 1 विल मेक इट और ब्रेक इट फॉर यू. पेपर 1 में यू हैव टू आंसर ऑल द क्वेश्चंस करेक्टली, है ना. तो ये था आज बिहार का. नेक्स्ट सेशन इज ऑन जनरल साइंस. जनरल साइंस से मेजर पोर्शन आता है बिहार में, और हम सब लॉ वालों का थोड़ा सा हाथ कमजोर होता है साइंस में, और स्पेशली वो जो कॉमर्स और आर्ट्स बैकग्राउंड से आ रहे हैं मेरी तरह. सो हमने इसलिए डेलिबरेटली जनरल साइंस को रखा है नेक्स्ट सेशन में. So I am expecting all of you to register and all of you to come for the general science webinar also. I'll be learning things. You will also be learning few of the things. At least practice हो रही है. Now you are relatively comfortable. अब at least आपको पता है कि आप किस position पे हो, है ना. तो ये था. And for torts and for contracts, there's a separate course for a law of contracts. हमारे लॉर्ड ऑफ द कोर्सेज जुडिशरी में, एंड द लॉर्ड ऑफ द कोर्सेज जुडिशरी इज ऑल्सो अ रनिंग कोर्स जो लॉसिको का एक कोर्स चल रहा है. देयर वी हैव अ डिपॉजिटरी ऑफ n numbers of MCQs on each topic. तो ये प्रैक्टिस सेशन यू कैन कंडक्ट इट ऑन योरसेल्फ आल्सो. सो या, लेट्स वेट फॉर अनु नाउ कि वो रिजल्ट्स अनाउंस कर दे, बिकॉज आज काफी ज्यादा पार्टिसिपेशन था, आज काफी ज्यादा पार्टिसिपेंट्स थे. दैट्स व्हाई ओके वी कैन टेक सम ऑफ द डाउट्स आल्सो. आई कैन सी निसार अहमद रेजिंग हिज हैंड. निसार, इज देयर एनी क्वेश्चन फ्रॉम योर साइड? प्लीज अपलोड द PDF of these MCQs on LawSikho website. On LawSikho website, yeah, the recording of this session will be uploaded on YouTube only. तो आपको वो आसान हो जाएगा. The links will be provided on the LawSikho LinkedIn page or the LawSikho this thing Instagram page. All other pages will provide the link. Yeah, go on, Jolly.
And guys, do not forget to give the feedback at the end of the session on the scale of 1 to 10, 1 being the very lowest and 10 being the highest. So don't forget to give the feedback. And you can give some like suggestions as well, like what more things we can inculcate in these live mocks.
See, when will be the ma'am plan? Please, can you repeat what is not voidable? Is it valid or void? What? Acha, horse racing wala? Are you asking about the horse racing question? And when will be the YouTube recording be available? YouTube recording will be available in
within this week. It will be available. Just stay tuned with the LawSikho website. और उसके पहले live mocks जो already हो चुके हैं दो, वो भी आ जाएंगे हमारे YouTube के उसमें.
YouTube पे जो LawSikho का वो है page, go and subscribe that page. You will see the webinar. Okay, Anu is back with us. Announcement time, guys.
Ma'am, will you take the land law?
Yeah, hi guys. I am back with the winners. So yeah, first of all, I'll say thank you to each and everyone who participated and stay tuned with us. जो हम लोग के साथ continuously थे. So the winners जिनके marks हैं, there is a very minimal difference. And now I'm going to announce their names. So I've selected 5 names as of now, but 3 people will be broadcasted on our LawSikho website or the other social sites which we run. तो अभी 5 जो मेरे साथ winners के नाम में लेने जा रही हूँ. So first of all, there is this participant जिनका number है 5700-686 something. So now I'll request him or her to please reveal his or her name. So that person has stood 5th, right? So very congratulations. Another participant who stood 4th is Kajal. So yeah, congratulations. And now I'm going to announce the 3 winners. So the 3rd winner is secured by 2 people. They have, secured like same number, same marks, I would say. So we have Manideep and 𝘧𝘃 Singh, right? So congratulations to them. At 2nd position, we have Pushpinder Kaur, right? And our 4th position is marked by Neha Gandhi, and this is very commendable.
Neha Gandhi has been a consistent winner, right, in both the mocks previously as well.
Right. She was securing 2nd, 3rd, and now she has stood,
first
in this particular quiz. So this was indeed very good session. And one thing that the 3rd जिसकी rank है और जो 4th है, there is only 1 mark difference. So it's good to see everyone, and they have participated. And I believe the participants have given their feedback to us.
वो 5001 वाले का I don't think so. He's revealing his or her name now.
Guys, please give the feedback.
Okay, no problem. Just if that person wanted to share his name or her name, so that's well and good. Otherwise, हमने 5 winners लिए, but 3 winners will be there on our LawSikho, post. So that's very good, and I'll appreciate each one of you जिन्होंने भी participate किया, and आपको काफी कुछ मिला होगा. You might have received so much of insight. So now please provide your feedback with us, and on the scale of 1 to 10. 1 being the lowest and 10 being the highest.
Which ID, Tasneem?
एक क्वेश्चन था ना, काजल का क्वेश्चन था आई गेस कि क्या क्वेश्चन था कि वैलिड है या वॉइड, वो हॉर्स रेसिंग वाला. ये रहा सेक्शन 30. एक्सेप्शन दिया है यहाँ पे, एक्सेप्शन इन फेवर ऑफ सर्टेन प्राइजेस फॉर हॉर्स रेसिंग, ये इसीलिए वैलिड है. ये हॉर्स रेसिंग वाला वैलिड है, बाकी सारे जो भी वेजरिंग अग्रीमेंट है वो वॉइड है.
Manideep Sakya, just go to the LawSikho websites. You will easily get the name of constitutional mock test winner. As far as I remember, it was Ankita, Vartika, and Neha Gandhi.
Neha Gandhi was one of them. I remember this.
Neha Gandhi was 2nd, I guess, in constitution. No, third.
Yeah, just Ankita Srivastava stood 1st,
Yes.
and followed by Vartika Mittal, followed by Neha Gandhi. In the another quiz of history and other, we had Rishu Bharadwaj. 2nd was Neha, and 3rd was some participant. I'm not able to recall. And yeah.
Yeah, Tasneem, there's no land law in Bihar. There's no local laws in Bihar. Land law तो यूपी और उत्तराखंड में है ना, UPZA Act. जमींदारी
Specifically for Bihar, these live mocks हम state wise held करेंगे. So make sure you let know your friends कि हमें free live mock मिल रहा है, इससे अच्छे opportunity क्या होगी. So let them know so that more and more people can access their preparation. और हम हर state का live mock करवाएंगे. और वो उसी बेसिस पे होगा जिस हिसाब की पार्टिसिपेशन रहेगी और सजेशंस।
हाँ एग्जैक्टली, अगर आपका मैक्सिमम पार्टिसिपेशन रहेगा तो विल बी कंडक्टिंग इट फ्रीक्वेंटली नाउ। और एमपी में है लैंड लॉ, एमपी की सीट्स आ रखी हैं, तो वील बी कंडक्टिंग द मॉक्स ऑन एमपी आल्सो जब थोड़ा सा डेट अनाउंस हो जाएगा तो उसके हम लैंड लॉ
विल बी कंडक्टिंग मॉक ऑन लैंड लॉ जस्ट
पेशेंस एंड नहीं आया ना, वैकेंसीज नहीं आई ना, आई डोंट
नहीं अभी नहीं आई है महाराष्ट्र की।
हाँ तो जब वैकेंसीज आएंगी देन वील टेक द दिस थिंग, लैंड लॉ पे भी हम ले लेंगे।
Right. So I think you guys have taken all the doubts from the participants, right?
Yes, we have addressed all the doubts.
Right. So now we will sign off the session. And thank you, Mahima and Jolly, for conducting such a beautiful quiz. And the participation was also very good. It's just some people joined it later, तो उनका थोड़ा सा score इस वजह से नीचे हो गया. Otherwise, जो first और second आए हैं, the people were still there since since the inception, starting से थे session में. That's why the people got it. So that was very good, and I congratulate again to all the winners for today's session. And now I'll sign off. Thank you, participants. Thank you, Mahima and Jolly again.
Bye.
Thank you, Anu, for such great company and moderation.
Thank you, Jolly.
And
Yes.
Mahima too.
Yeah, thank you, Jolly. Bye.
I'll sign off. Webinar Executive Anu Bhatnagar.